resuming. No, you can do your motion. We are resuming meeting number 12 of the House of Commons Standing Committee on Human Rights. Everyone knows the protocol about being respectful around the microphones. Les tests de son, Monsieur Fortin, ont été bel.
The sound tests have been conducted.
Numbers that we are still dealing in the third hour with the sub-amendment from Mr. Lawton on to Larry Brock's motion. The first panel is composed today in person of Mayor Patrick Brown from the City of Brampton. Welcome, Mayor Brown.
Monsieur le Président,
Mr. Chairman, a point of order. We don't have a notice of this meeting, and mine said that we were resuming the debate on Mr. Brock's motion from meeting number 12, which was suspended. So I'm expecting that we will be continuing meeting number 12. I haven't received any other notice of meeting.
À nous proposer pour nous ramener.
We wanted to come back to this format so that, and I'm giving you the surprise, we have two panels, and then in the third hour, we are going to deal with the sub-amendment moved by Mr. Lawton to Mr. Brock's motion. So I would ask him to, well, now you're telling me, you're announcing this as a surprise to me. And you're admitting that to me, but is this the normal way of proceeding at the Justice Committee? I've been here since 2019, and this is the first time there's been a surprise notice of meeting before. Normally, we are told in advance, we prepare the meeting. I'm not ready for what you're announcing right now, so I don't know what my colleague, Mr. Brock, wants to propose. It concerns him, but Mr. Brock and Ms. Lattanzio perhaps discuss this. And we can filibuster. There's often this kind of war between the Liberals and the Conservatives, and I'm happy to know that's over, but I'm not happy to see that we're going to proceed with a surprise meeting. It seems to me that we could have been speaking, all three of us. I was on the phone for an hour on Friday with Ms. Lattanzio. She sent me another email I responded to yesterday. And at that point in time, we were discussing Mr. Brock's motion. And in the meantime, I have a notice from the clerk telling me that we're going to continue with the 12th meeting that was suspended. So, and now all of a sudden you're telling me, Mr. Fortin, we've changed our minds. I don't think we can proceed in this way. Well, we can allow Mr. Brock to propose the motion. Normally, we would have had these witnesses here today. The members should all be ready, but I'll allow Mr. Brock.
Je m'excuse, mais ce que vous venez de...
Mr. Chairman, I'm sorry, but you're telling me that I'm not ready when I should be. I never received a notice of this meeting for the witnesses who are supposed to be appearing, so don't tell me that normally that's the way it works. It doesn't work that way. Normally, we get a notice of meeting, and we work according to that. Today's witnesses, with all due respect for their credentials, they're not on the agenda. And more they're competent, more they're useful, the more I want to be prepared myself. So having this surprise, I don't find this fair, and I don't find it effective. This is not a serious way to proceed, Mr. Chairman. I'll allow Mr. Brock to move his motion.
Thank you, Chair. And I thank Monsieur Fortin for his intervention. I too would like to know why we did not receive a notice of meeting with respect to potential witnesses. It's unfortunate that that was not done. But for the purposes of resuming debate on my original motion, which was then amended, which was then sub-amended, I have a proposal that I have circulated to every member at committee. I believe we have an agreement to conduct the balance of this meeting in the following fashion. I wish to read the motion out at this time. That for the purposes of today's meeting, the committee dedicate 2 hours to witness testimony on the study of bail and sentencing, and in the third hour, conclude debate on the conservative motion in relation to the Supreme Court ruling dealing with mandatory sentences for criminals convicted of possession of child sexual abuse and exploitation material.
That was proposed by Mr. Brock that you've read out. There is no specific amendment on that. And on that, let's go directly to a vote on that motion.
Unless we have unanimous consent.
Well, we need a unanimous consent to pass this motion. So all those in favor of passing this motion, say aye. All those against? Okay, so this motion fails. And unless someone proposes another motion, we will have to resume to the regular programming.
Resume the programming debate.
Mr. Lawton,
Just to add to the speaking list.
your proposal, Mr. Brock, is to, there's no other motion proposed on the table? Yeah, Ms. Latanzio.
I'm going to move a motion. I don't know if I'm on. Just give me 2 minutes. Sorry about that. I know I can't read it. Mark on.
Yeah, go ahead.
Okay. I move, Mr. Chair, to now hear from the witnesses.
Okay. That's immediately votable, so all those in favor? Okay, all those against? Okay, the motion is carried. We will now,
Président, j'ai un point d'ordre là-dessus que j'ai.
Point of order, Mr. Chairman. I said that we did not receive a notice of meeting, and with all due respect for these witnesses, with which we have to work with seriously, they're here to do an important job, and I think that we have to be properly prepared. So you said to me earlier, and I thank you. It was a surprise to me. It's not my birthday, and I don't need surprises like that. And I don't agree that we continue without a notice of meeting. So I'm making this a point of order, Mr. Chairman. The committee cannot meet without a notice of meeting. I don't know if it's 24 or 48 hours. It can't be decided on the fly like that in the morning. Not the morning, even in the afternoon at 3:30 at the beginning of the meeting.
vous n'avez pas tort en partie.
Well, you're partly right. The notice of meeting is a custom, but given that we've voted on the motion, we can pick up where we were supposed to be today, which is to say that the witnesses for this study. So we having voted on the motion, Mr. Chairman, I have a notice of motion that says what we are doing today is that we are resuming meeting number 12, which was suspended. That is a notice of motion that I received today, and like all the other members. So don't tell me that we were supposed to hear these witnesses. That's not what we had on the notice of meeting. So I don't know where this idea comes from that we should hear from these witnesses. I believe it was discussed probably in good faith by colleagues around the table who thought it would be useful to hear from these witnesses. They're important people who deserve to be heard. But I regret we have a way of proceeding, and we can't move with chaos. We have to have some kind of order. I understand your point very well, but we just adopted Ms. Latanzio's motion, and on that note, we will hear from the witnesses who have been waiting patiently for a good half hour. So you say you're going to hear witnesses on the basis of a motion here when we haven't been convened to meet on this subject? That's your decision? Well, I challenge that.
Are in favor of Mr. Fortin's challenge to this chair? Yes. Shall the rules, again, in reverse, shall the chair's ruling be sustained? All those in favor say yes. Sustained? Yes. All those against? Nous allons, Monsieur Fortin, nous allons procéder au témoignage. We will start first with
Okay, we'll begin with the testimony.
Mayor Brown, who's here in person. Mr. Brown, you have 5 minutes, and the other witnesses by group will also have 5 minutes. Thank you, Mr. Brown. Over to you. Yes, we can hear you.
Okay, great. Well, an honor to be here at the Justice Committee. I once sat on this committee as a parliamentarian, and I know the important work that you undertake. And it heartened to hear that you are having this extensive look at bail reform in our country. We have a bail system in Canada that is tragically broken, and it is very encouraging to hear that it is being addressed with the attention that it deserves. I represent a city where I believe public safety is the number one issue in Brampton and in Peel Region. And I see that through my responsibilities as not only as mayor of the city, but as a member of the Peel Regional Police Services Board. And for the last 5 years, we've had a campaign for bail reform. We launched a petition, and we have had it as our number one advocacy point in Ottawa. What started this campaign was the tragedy of Darian Henderson Bellman, who lost her life to 5 shots from her former intimate partner. This individual was released on bail 5 times. It was a preventable tragedy. More recently, and I say tragically, almost every few months we hear another example of this. After Darian Henderson Bellman, we should have said never again would a preventable tragedy like this happen, but that hasn't been the case. Just a few weeks ago, we paid witness to the tragedy of Savannah Kula. Savannah Kula had her life taken from a former intimate partner who had a history of violence and firearm offenses. And the fact that he was released to take her life is a tragedy that shook our community. And it's why I believe the bail reform presented is so necessary for the country. We have the same criminals committing the same crimes again and again and again. It has become a revolving door. We even had one instance in Peel Region the chief of police told me about where someone was released for stealing a car and stole a car from the parking lot of the courthouse in Brampton. To the point that on talk radio they were laughing about it, but it's no laughing matter for those whose security has been pierced. I wanted to share some stats with you. I did some research in advance of this testimony. In Peel Region, 66% of those who have firearm offences have been released on bail. So 66%, two-thirds of the individuals who committed firearms offences were released. That is, someone who commits an offence with a firearm should not be released. These are people that have terrorized the community, and the seriousness of a firearm offence should be treated as such. I'd also wanted to note that I understand that it's not simply the criminal code. We have serious challenges to correctional capacity and judicial resources. And I wanted to put that on the record as well. We are short crowns, short interpreters, and too often at Maplehurst, our local correctional facility, the inn is full, and there is no capacity to send additional inmates. Almost every case in Peel Region is given additional credit when it comes to sentencing because of the challenges of the system. And so my plea today, on behalf of my residents, is that this robust bail legislation needs to be passed. And whether there are amendments that are required to strengthen it, I don't believe public safety should be a partisan issue. Let's make sure that this bill is as strong as possible, and we give people in Peel Region, residents in Peel Region, and frankly Canadians across the country the peace of mind that they deserve. You know, talking to frontline officers, you know how frustrating it is for them to have their hard work wasted when an individual they spent hundreds of hours on is released. I look at Project 24 Carat, where we had this massive expense for the Peel Police and the largest gold heist in Canadian history. Everyone who was charged in Canada was released. The individual charged in the U.S. is still in custody. And there are too many examples like that. I wish this legislation could be adopted immediately in the House of Commons so that that frustration, that anger that I hear from police who see their time wasted, that we don't see that anymore. And frankly, I hate getting the phone calls from parents who lose a loved one. Savannah Kula's father called me saying that he saw the Darian Henderson Bellman tragedy on the news and said, I hope this never happens to my family. Spoke to Darian Henderson Bellman's parents as well. They came and spoke at our Peel Regional Police Victim Symposium, which we hosted for the first time this year, to really amplify the need for bail reform. Talking to parents who have lost a loved one where that loss should never have happened is tough. And so I want to thank you for giving me the opportunity to say a few words, and thank you for paying attention to a topic that is so critical to Canadians.
Thank you, Mayor Brown. We now have the Deputy Chief of Police of the Toronto Police Service, Robert Johnson. You have the floor for 5 minutes.
Thank you, Chair. Members of the Standing Committee on Justice and Human Rights, thank you for the invitation today. The Toronto Police Service has long advocated for reforms that put public safety first, including bail reforms and reverse onus provisions that properly address serious violent offenses, repeat violent offenders, firearms offenses, organized crime, and intimate partner violence. We support the Canadian Association of Chiefs of Police submissions made to the committee on October 28, 2025. I'd like to offer some context on what we are currently facing here in Toronto. Policing in the biggest city in Canada is complex, and we consistently have to adapt. Over the past decade, there has been a general increase in the volume of shootings and firearm discharges. Although we have seen more recent declines, particularly over the last 5 years, the longer-term trend remains concerning and is the focus of our planning and resource allocation. Auto thefts have decreased since 2023. However, we have seen a steady upward trend over the past decade. Auto thefts have, home invasions are down as well compared with last year, but this follows a notable increase in recent years, upwards of 400%. We believe that the Bail and Sentencing Reform Act, introduced last month by the Minister of Justice and Attorney General of Canada, is a step in the right direction to protect the public and deter criminal activity, to rebuild public trust in the justice system, and to strengthen morale among police officers. For example, the proposed amendment to modify the tertiary ground for the denial of bail to require courts to consider the number or seriousness of any outstanding charges is warranted. Despite crime indicators trending in the right direction this year in Toronto, certain high-profile cases involving reoffenders committing violent crimes while out on bail continue to undermine public trust. And for our frontline officers, as Mayor Brown had mentioned, when they keep arresting the same individuals over and over again, they feel like their work doesn't make a difference. Recently in Toronto, we arrested 3 individuals who were all under 18 at the time of the crime in August. This was for the murder of an 8-year-old who was struck by a stray bullet in his bedroom. Although there has been a slight decline this year, we continue to see more young people becoming involved in gun-related activity. With a clear rise over the past several years, this increase reflects a troubling shift in both accessibility and attitudes towards firearm among youth. This is a serious challenge that requires a whole-of-society effort. In a densely populated city like Toronto, shootings in public spaces are not only incredibly dangerous, but they can also cause lasting trauma and uncertainty for survivors, families, and entire communities. Therefore, we continue to argue that when someone is shot and killed in a congregate setting, such offenses should be classified as first-degree murder under Section 231 of the Criminal Code. This amendment would act as a strong deterrent to perpetrators and recognize society's condemnation of such that the overwhelmingly majority of crime guns seized and sourced by Toronto police come from the United States, ranging from 73% to 89% in the past 5 years. Guns that can be traced, and in all likelihood, the total number of crime guns from the U.S. is probably a lot higher. This highlights the importance of strengthening collaboration with other law enforcement agencies and for enhanced financial support and resources for policing. This also highlights that meaningful and lasting progress requires a whole-of-system approach. For example, modernizing lawful access provisions and strengthening legislation to help prevent the movement of contraband, firearms, and dangerous drugs is also essential. The Toronto Police look forward to continuing our work with all levels of government to ensure that the justice system upholds accountability and protects our communities. Thank you for your time.
Thank you, Chief. Colleagues, we have, unfortunately, because of the time constraints, we will have only a chance for one full round for this panel. I do hope it'll be a productive one, and then we'll go into the second round of witnesses. It'll start off with Mr. Baber, followed by, I don't have the Liberal, Ms. Latanzio, et ensuite Monsieur Fortin pour 6 minutes chaque. Donc la parole est à vous.
Then Mr. Fortin for 6 minutes each.
Welcome, Deputy Chief Johnson. I want to begin by thanking the Toronto Police, the Chief, frontline officers. My constituents are protected by 31 Division and 32 Division in North York, and I thank you for your service. I first came to Canada 30 years ago directly to Shepherd and Bathurst, where I'm now pleased to be the sitting member of Parliament. Last Sunday, just like the Sunday before, a group of thugs went into a residential neighborhood and marched up Hove Street and then turned onto Codsall Street, scaring and intimidating local residents, primarily making up Toronto's Jewish community. Is that acceptable behavior in your view?
Thank you for your question. It's a complicated situation for sure. And what I can tell you is our officers are there observing and will lay charges when we feel the criminal code has been breached. You know, it's upsetting for the neighborhood. We are aware of that. We're trying to do everything we can in partnership with, the municipal government bylaws that have been enacted in the area.
I apologize, my time is very short. What do you think is the intent of this crowd when they walk up Hove Street into a residential neighborhood?
Well, they're pushing the line for sure. They're trying to annoy residents. The
Okay.
issue that we have to deal with is this criminal activity.
Well, I submit to you respectfully that their intent is to intimidate local residents, and they do so successfully. My constituents are frightened. They chant. They yell at neighbors. You would agree with me that local residents would rightfully be scared when they see that. Would you agree with that or not?
100%, but it does not reach the criminal threshold of harassment.
But would you
Our
not agree
legal
with me
advice.
that the intent of that crowd is to intimidate the residents that they're passing by?
I would agree with you that it disturbs residents of the area 100%. The issue is we have to have evidence of a criminal offense before we can lay a charge of intimidation. And in our, the advice that we've been given, our legal advice is that does not reach the threshold, the current activity that is occurring there.
Officer, if you agree with me that the net result is intimidation, and I think you'd agree with me that the intent is intimidation, then that is no longer protected charter expression. I believe at the very least it is mischief. And I'm asking the Toronto Police to respect Toronto's residents and the residents of Bathurst Manor and protect them appropriately. We cannot have thugs walking through local neighborhoods terrorizing the neighbors.
So the devil's in the details that you use. Again, I'll reiterate that our advice that this is not criminal intimidation. It is disturbing to the neighbors, the neighborhood for sure. We are there to make sure that public safety is upheld. And when we find evidence of a criminal offense, we lay charges. We have a track record of that. We have laid, I think, 768. We've
I'm sorry,
almost.
I'm sorry, Deputy Chief. I submit to you that it is a criminal offense, and I'm going to cede the rest of my time to the member for Brampton West.
Thank you, Chair. Thank you. My question to Mayor Brown is, Mayor, thank you, Mayor, for coming here. And my question to you, do you believe that we must ensure that the proposed Liberal bail reform should be properly amended and strengthened to avoid any leak from government oversight?
Peel Regional Police, our Chief of Police and our Police Association have endorsed this legislation. If there are ways to strengthen it, then I would welcome that as well. We want to see bail legislation that has real teeth. And the fact that our Chief of Police and our Peel Police Association have expressed support, and I would, for that matter, note the Ontario Police Association as well, is encouraging.
Okay. My another question, do you support our Jail Not Bail Act?
I support bail reform, whether it's the bail reform put forward by the Conservatives or the current legislation. We need change. The current bail system in Canada is broken, and I am encouraged that we're seeing change coming.
You and I have seen Brampton has one of the epicenters of violent crime linked to offenders repeatedly released on bail. Do you agree?
Yes, we have had one case, the Peel Police told me, of someone who was arrested 51 times.
Yeah. And I know you have said that we need to have the robust bill, and everyone who came here said it's a good start, but there are some gaps that need to be filled out. So do you agree that we still have to close those gaps to make it robust?
If there are amendments that would be helpful, that the police believe would be beneficial, then I hope those amendments would be adopted. But I do hope this legislation can be passed as quickly as possible, whether it's amended. The status quo is broken.
One more time I would ask, you must have seen Jail Not Bail Act, and do you see that is going to strengthen our bail reform laws?
I think that was positive legislation that was proposed. I think what's come forward is positive legislation. I'm glad that we're finally at a point where this is being addressed.
Like 20 seconds.
Yes
or no, quick.
Okay, I can. Can you speak? Well, I will ask another question. Can Brampton afford to wait for these gradual reforms, or must we act to reinforce it now?
Yesterday.
Yesterday. Here you go. Thank you.
Ms. Latanzio for the same time. Thanks, 6 minutes.
Thank you, Mr. Chair. Thank you, Deputy Chief Johnson and Mayor Brown for being here today and contributing to this very important study. Mayor, you said publicly, and I quote, "I support the federal government's action through Bill C-14 to strengthen bail and sentencing laws." Can you explain to us in more details why you believe these reforms are urgently needed, as you've said a couple of times here today, but why specifically, that you believe that the reforms are imminent?
Well, if I could give you the best illustration, is I asked our Peel Police leadership team, I said, if this legislation was passed, would Savannah Kula's tragedy have occurred? Would Darren Henderson's, Bellman's tragedy have occurred? And they said no. And if those lives could be saved, I know there's countless others that could be saved in the future. I think this will change the nature of the revolving door. I don't think the justice system is simplistic. There are other changes that are needed, but this will be very helpful.
And you also have told Parliament, quote, "You welcome the federal government's announcement on bail and sentencing reform, and that you hope the legislation is passed right away, as you've mentioned a couple of times here today." Why is the immediate passage so important from your perspective?
My worry is that there are individuals being released on bail today that this legislation could catch. And I would note we're grateful that the Peel Police input was heard in this process. We were up in June meeting with the Minister of Justice, the Public Safety Minister, and the Combating Crime Minister to make our submissions on the legislation, and we're grateful that the government has listened to the input from the Peel Police.
Okay, you've described our Bill C-14 as a very positive step in the right direction for public safety. Which elements of the bill do you believe and consider will make the biggest difference in protecting communities like Brampton?
Well, I certainly think repeat offenders, the aspect that addresses individuals who are repeat in nature is going to be helpful. Obviously, the components around intimate partner violence and the use of firearms. We've declared a gender-based violence epidemic in Peel Region, and the fact that is going to be taken more seriously now is very positive. I know that's the way my residents feel.
Okay. And do you believe C-14 reflects what municipal leaders like you have been calling for on stronger bail and sentencing measures?
I think it is largely very positive. I trust the judgment of my Chief of Police, Nishan Dirapa, Adrian Woolley from our Police Association. They've looked at the legislation. They have publicly endorsed it as a very significant positive step forward. And they're the ones on the front lines. They're the ones that see the most heinous individuals commit crimes and break our trust. And when they say this is going to be helpful, it's why I'm supporting it.
Okay. C-14 is currently being debated in the House as we speak. Would you advise the parliamentarians to move quickly, rapidly on this important piece of public safety legislation so that the committee can study it as soon as possible?
Yeah, I hope there is no delay or dithering. I think lives are at stake in terms of having legislation that fixes the revolving door nature of our justice system. That's not to ignore the correctional capacity issues and the judicial resource shortages, but I believe this legislation will be very positive. If there are amendments that make it even stronger, I would welcome those, but I think this legislation is going to be significantly positive.
We await for that legislation to come at this committee, and hopefully we'll be able to hear from you and maybe Deputy Chief Johnson once it makes its way here. But we take good note that you highly recommend the parliamentarians in the House send us this very important piece of legislation ASAP. Thank you for your time.
Thank you.
Thank you.
Yeah. Phil?
And cede the floor to,
Thank you. Look, Mr. Gill hit the nail on the head, in my opinion. He said, can we afford to wait? Your answer was no. You started by saying this is a robust piece of legislation. Let's get it done. Every single witness who's come before this committee, Mayor Brown, has said virtually the same thing. However, and I'll only have 2 minutes, one of the biggest challenges that we face in this entire discussion, the other thing you said is this is not a partisan issue. I couldn't agree with you more. It's been turned into a partisan issue. And it's so unfortunate, it's disgraceful. What advice would you give to people in the House of Commons to tone down the rhetoric? Because it creates, we have a justice system which is, it's a strong system. It needs to be improved. We're taking our part to do it. But what advice would you give to those who insist on snipping, clipping, and posting on Facebook, for example, or using this negative rhetoric to criticize a bill which you and Deputy Chief Johnson and so many others are here urging us to pass?
Well, I'll share the same advice I shared with the Minister of Justice in June when I was up here with Chief Derapa, and I said we all have to own our areas of responsibility, and it doesn't help, and we're all finger-pointing at each other, whether it's the municipal government or the provincial government or the federal government. Frankly, I think we look a little immature when we're in that finger-pointing stage. We just need to fix this. Residents don't care what level of government do it. They just want to see a system that they feel and they see is broken is addressed. And so I know that Ottawa, there's a partisan confrontational dynamic. That's our parliamentary system. But I believe this legislation, bail reform, was needed 10 years ago. The fact that it's happening now is good news.
Thank you.
Thank you, Mayor Brown. Monsieur Fortin, la parole est à vous. 6 minutes.
Mr. Fortin, you have the floor for 6 minutes. Thank you, Mr. Chairman. Mr. Johnson, and first of all, thank you to both witnesses for being here today. You were watching the previous debate, and I can assure you that this procedural debate has nothing to do with the importance of your testimony, and I'm very pleased to be hearing you on this important issue. Mr. Johnson, I'd like to ask you, could you tell me if you have any statistics on the percentage of people in prison who are in remand versus those who've been sentenced to a term in prison?
Unfortunately, I don't have those here. I can certainly get them. I want to make sure that the information is accurate. I don't have them with me today.
Et est-ce que vous savez si c'est disponible?
Do you know if that information is available?
Yes, it is.
Pouvez-vous nous en envoyer une copie si vous...
Could you send us a copy if you obtain that, please?
Yes, I will do.
Merci, Monsieur Johnson. J'aimerais également...
Thank you, Mr. Johnson. I would also like to ask you, are you aware of the percentage of crimes that are committed by individuals who are out on bail?
Yes, I think Mayor Brown quoted the figure of about 66%. I think in the City of Toronto, it is a little bit higher than that, upwards of about 70%.
Microphone, please.
Par des gens qui...
The interpreter regrets, but the first half of the question was not audible. The microphone was not on.
You need to repeat it. Interpreter didn't get it.
Sorry, my answer or your question?
je répète ma question.
I'll repeat the question. Are you aware of the percentage? I'm sorry, Mr. Johnson. I want to make sure we understand each other. The percentage of crimes that are committed by people who are out on bail. So people who are awaiting trial and have been freed on bail. So if you take the total number of crimes committed in your region, do you have an idea of the number of crimes or the percentage that are committed by people who are out on bail?
Thank you for that. My misunderstanding of the question originally. I don't have the exact figure here. I mean, we would have to look at, if we're talking about violent offenses or all crime in total, which I know we have. I do not have those with me today.
Merci.
Thank you. I'd like to ask you, are you aware of the figures concerning the increase in crimes committed by repeat offenders, so people who have already been found guilty and who commit other crimes? So are there any statistics on that? Has that gone up over the last 10, 20 years? Do you have any statistics on that?
And I don't have them with me. We do capture that, and there has been a dramatic increase. I know that for certain. The exact figure I do not have with me today, but can get that to you.
Okay.
Okay, thank you. Can you, and you're going to find me tiresome, I'm asking for statistics, but I'm trying to be efficient here. The rate of rehabilitation for criminals, people who have been found guilty of a crime, I put them in two categories. Those who we send to jail, who are going to serve their sentences, and those who have conditional sentences. So are we in a position to assess the rate of rehabilitation of these people?
Well, I think we'd have to work with Corrections Canada on that, but certainly from a police perspective, offenders who reoffend, we do capture that. And again, if we're talking about what category of crime, all crime right across all indicators or violent crime. So again, I apologize. I do not have those with me here today, but for what we capture, I can certainly provide that.
Ben, je vous remercie, Monsieur Johnson.
I thank you, Mr. Johnson. I would like to ask you, Mr. Brown, the same questions, but I imagine you don't have those statistics any more than Mr. Johnson.
Regularly ask our Crown Attorney, provincial Crown Attorney, for updates on the numbers. The 66% figure I was referring to was for offenses with a firearm. And so, unfortunately, the majority of offenses, serious offenses, are given a bail today.
OK. Et ce chiffre-là de 66,
And this figure of 66%, you're saying that these are gun crimes. So 66% of what?
Offenses that involved the firearm last year in Peel Region.
OK, 66% des crimes qui ont été commis.
So 66% of the crimes committed in Peel Region last year were committed with guns. Thank you, not Johnson, sorry, Mr. Brown. I thank you. There are witnesses who are telling us that the prisons are filled with 60 to 70% of people, with people who are awaiting trial. So are you in a position to confirm that, Deputy Chief Johnson?
Sorry, your figure was what?
Plusieurs témoins ont dit que
Several witnesses said that more than half of the people in prison, and I think it was 60 to 70%, who were people who were awaiting trial and not people who had been sentenced to prison. Are you in a position to confirm that figure?
No,
et Monsieur Brown, j'imagine vous non plus, vous n'êtes pas au courant.
And Mr. Brown, I imagine you're not either?
Get this briefing that dead time is awarded on every case where an accused has spent time at Maplehurst, and that is due to lockdowns, triple bunking, and a lack of access to programs. So sometimes they'll get triple time.
Oui.
Monsieur Fortin, temps est complet.
Merci.
Thank you to both witnesses, Chief Johnson, Mayor Brown. Thank you individually for your services, your service to Canada. We will suspend, colleagues, briefly to transition to the next hour. We have 4 witnesses that we have to get prepared and logged on. So we'll take a brief break and then resume in about 5 minutes max. Thanks. Thank you for being patient. We were just trying to get Ms. Wambach from the Canadian Crime Victim Foundation online. That has not been entirely successful, so we'll let the technicians work at it as we start this next round. Apologies and welcome to witnesses, and apologies for the delay today. We will try our best to get 2 rounds of questioning in from members, so I will not take up too much time in introduction. Just to present people here today, we have in person Jacqueline Basil-Cobb, Accounts Receivable Western Financial Group. Welcome. Kate Alexander, welcome to you as well, the founder of End Violence Everywhere. Then Brett Broadfoot by video conference. And if we are successful, Lausanne Wambach, the co-founder of the Canadian Crime Victim Foundation. Just again, brief reminder for our interpreters to not speak too loudly, keep a distance from the microphone, and avoid sharp banging around the microphones just for the sake of our interpreters. Sans plus tarder, je commencerai avec les...
Without further ado, you'll have 5 minutes each for your presentations for each of the witnesses, and we'll start with Ms. Basil-Cobb.
And successive 5 minutes for the rest of the witnesses. Welcome. Please go ahead.
Thank you. Thank you, Mr. Speaker and members of the committee. My name is Jackie Cobb, and I'm here to speak on behalf of my 23-year-old daughter, Madison Cobb, whose life was brutally taken away from her by her ex-boyfriend on July 19, 2025, in a parkade in Calgary. Before Madison could get into her car to come home to her family, she was gunned down by her ex-boyfriend, leaving her dead at the scene. I'm thinking of my Maddie. Think of your own daughter, or sister or niece. Now picture them left to bleed to death with no one there to help them. Imagine their fear. My Maddie was a bright, passionate, respectful, cheery, and accomplished young lady. She excelled academically, was a competitive swimmer, and had just begun a promising career as a surgical eye assistant at LASIK MD. Her life was full of potential. Madison deeply impacted and connected with people. She was on a mission to save individuals who needed saving, even if it was just helping, guiding, or just being a friend for those who didn't have one. She was always there when called upon, always lending a hand and never complaining to help others. She was a girl with strong family values, was a best friend, and always saw the bigger picture in life. She was an old soul, acting beyond her years. She cared about people, something most of us have lost throughout the years. Although she is no longer with us, today Madison continues to try to help others. By my appearing before you, I represent her desire to find justice in a system that failed her when she needed it the most. My Maddie followed every legal avenue to ensure her safety. A restraining order was granted on June 10, 2025, against her offender, who also had 2 criminal harassment charges against him for stalking her, and was released on bail on June 10th and June 17th. He was known to have a firearm in his possession as well. The restraining order did not do its job. It was a piece of paper with meaningless words. The judge knew about the criminal harassment charges and the known firearm when Madison was finally granted the restraining order, yet nothing stopped him from walking out the court, free to plan and carry out this horrific act. Madison deserved to live without fear. She was not protected by the system. Madison became a victim of a violent crime and paid the ultimate price. This was not a moment of anger. Every action was calculated. He stalked her, he waited for her, and he executed his plan. The nature of this deliberate act should automatically remove any possibility of bail or leniency. He chose to take her life. He should be held accountable. I stand here before you on behalf of Maddie and the thousands of women and men who have been impacted by domestic violence. Maddie is not the first person to suffer at the hands of the legal system, and she will not be the last, unless a stand is taken to change the current system. Please, I urge Parliament to enact stronger consequences for the repeat offenders and those who breach protective orders. Early intervention, such as mandatory evaluations and monitoring the offenders, this could prevent escalation and save lives. We must prioritize the right to live a life protected by law in safety from such criminals. How many innocent people need to die, like my young daughter Madison, for legislation to change? We all know the law is broken. We hear legislation might change, but it never does. Parliament has the knowledge, the power, and the authority to make the necessary changes to implement stronger sentencing now, before more innocent lives are taken. The system needs to change. Why are we so forgiving and give the offenders so many chances? The criminals know our system and its loopholes, and they are taking advantage of it. Please protect the innocent. Criminals should not have the same rights as you and I. My life has changed forever. I will never see my child walk through that front door with her incredible smile, knowing she is safe. I can't kiss her goodnight, say I love you, or call her when something is exciting. I won't have the joy of seeing her walk down the aisle or having kids of her own. All I have left are photos and videos to help her remember every detail of her appearance and listen to her voice on tape so I can hear how she spoke my name. I hold her clothes so tight so I can remember how she smelled, and I hum her favorite song in my head all the time because I don't hear it blaring from her room any longer. Now I have to look at an empty chair at my dining room table where she sat when we ate. I walk past her room with a constant sadness of the good times we shared in that room. There will be no more treasured family vacations we loved taking together. Now I have a constant worry. My family will fall apart because of this crime, like so many other families have. I stand here today to advocate for change, so no other family endures this pain. You never think it will happen to you until it does. You can make the difference. Hold them accountable on their first offense, so this tragedy won't become your nightmare as I am living for the rest of my life. Thank you.
Thank you, Ms. Basil Cobb, and your courage in testifying today. We will go directly to Ms. Alexander and then to Mr. Broadfoot.
Love you, honey. Thank you to the members of the committee. I want to begin by commending you on what has clearly been a tremendous success, a justice system so efficient, so protective, and so flawlessly designed that victims and survivors across this country have nothing to fear. And I honestly don't think that we need to be here today, so we might as well just go home. But we can't go home, because none of the aforementioned is remotely accurate or truly reflective of the graveyard of preventable deaths that Canada has become. My name is Kate Alexander. I'm a model, actress, artist, and founder of End Violence Everywhere, a registered charity in Canada serving survivors of intimate partner violence, sexual assault, and gender-based violence. On July 31st, 2021, I was nearly killed by my former partner in Leaside in Toronto. Despite the severity of the attack, having photo and video evidence of him nearly beating me to death, despite the tactical team coming to my home, despite 8 charges he faced, he was released on bail almost immediately for $500, and I've never even had a criminal trial for my attempted murder because all 8 of his charges timed out under Jordan's rule. I don't even have a peace bond because it expired. I lived in hiding for months after the attack before being forced to move to the United States. And had I not left Canada, he probably would have been successful in his quest to end my life. He nearly did that to the woman he dated after me, and I found out the one before me as well. The scariest part is my experience is not unique. It is common in Canada. Abuse is happening to women, children, and yes, men as well, every single day in this country without consequence. At my organization, we serve these survivors that we call the experts because they are the experts of these issues, their experience, and the horrors of not having a functional justice system. If you have not engaged with the system nor read the entirety of the Criminal Code of Canada, I would not call you an expert, regardless of your parliamentary title. We, the experts, call it the injustice system, and we live the damage that it does every single day. A most recent example is of a club promoter, Mark Holland, who notoriously has sexually assaulted dozens and dozens of women spanning generations. He is on the registered sex offender list, and this past August was released on bail for more sexual assault charges as free in the community once again. I met Mark when I was 18 years old outside of a nightclub on King Street West in Toronto, and something in my gut told me to stay away from him. My instinct was beyond accurate. Over the last decades, I have watched Mark Holland harm 8 of my friends and brutalize dozens and dozens of other young girls with impunity, and he's out on bail again. I have seen hospitality groups and clubs continue to hire him despite knowing what he does. I have seen him breach conditions repeatedly and still remain free. still working in nightlife venues, still hunting victims, still protected by systemic gaps that enable serial predators. It's almost as if the government wants this. Our team at EVE is supporting hundreds of survivors, and we receive thousands of disclosures online and directly through our advocacy channels. These are not fringe cases. These are Canadians, primarily women and children who are unsafe in their homes, unsafe in their communities, and unsafe because the system that is supposed to protect them protects the abusers. The charter rights of criminals appear to outweigh the charter rights of victims. We are supporting survivors who sleep with bags packed by the door. We are supporting survivors who relocate provinces because their abuser was released. We are supporting survivors who have been told directly that the system cannot help them until something worse happens, until the blood is drawn. And even then, in those instances, as I know from personal experience, it's not enough. The only time it seems to be enough is when she's buried. We have to die, and then you care. Sort of. Dozens have been killed recently by partners who were released on bail despite clear histories of violence. Two of the parents of these women are testifying today, my friend, Jackie Cobbs and Brett Broadfoot, and it is my honor to call them my friends, but I wish I didn't have to meet them because their daughters were murdered in preventable death simply because the government doesn't have good policy and doesn't care. Don't tell me that you do care like you did, James Maloney, on October 28, 2024, when we met under former Minister of Justice Arif's reign. You promised me you would see our pleadings through. You promised me that having a family of lawyers helped you understand firsthand what we go through. You promised me that you cared, and you promised me that you would do something about the horrors of the Canadian criminal system. And I left your office that day hopeful. How stupid of me. You never called me again.
Ms. Alexander, your time is up.
All
If you
right,
could briefly
then leave it
conclude.
right there.
Thank you. Mr. Broadfoot, over to you for 5 minutes, please.
Good evening, committee. Thank you for having me here this evening. Again, my name is Brett Broadfoot, and I'm here to speak for my family, and most importantly, for my beautiful and now deceased daughter, Brianna. I hope also to speak on behalf of other victims of intimate partner violence. For all the women who continue to live in fear of their abusers because they are still out on the streets after being charged, with no accountability for the violent acts they have committed. I would like to share my family's personal experience at this time. On March 15th of 2024, my daughter Brianna was brutally attacked by her boyfriend. She was left with 2 black eyes, a fractured orbital bone, several other broken bones in her cheeks, and severe bruising around her neck from his hands having been wrapped around them in strangulation. She was only 16 years old at the time. Her attacker, aged 18, was arrested on March 15th and charged with assault plus assault with choking and suffocation or strangulation. He was released from custody on the same day he was arrested. He was sent, after being scheduled to attend court again on July 31st, 2024. He was sent with orders to not communicate, or go near my daughter, as well as refrain from possessing any weapons. We couldn't believe he was released, just allowed to continue as if nothing happened, while Brianna remained in the hospital struggling to recover from the injuries he had inflicted upon her. Our family felt that we had zero help or support during this time. We were set to sit alone with the knowledge that our attacker was just out there, unmonitored and unchallenged, ready to assault again whenever he wanted. Unfortunately, that thought came true. On July 16th, 2024, Brianna, now 17, was attacked again by the same individual, but this time in a much more serious way. At approximately 1 a.m. on July 17th, we were woken by the sound of a police sergeant knocking on our home door. We were told that our daughter had been taken to the critical care trauma unit at Victoria Hospital with multiple stab wounds. We were told that the same individual had abused her again. Brianna fought as hard as she could, but unfortunately passed away from her injuries on July 18th, 2024. We lost our baby girl. Our worlds have changed forever. To this day, I truly feel that Brianna could and should, could and should still be with us if her abuser had not been released after the original attack, or at least monitored. Our system completely failed us, just as it has failed so many others in the past. We need to stop the catch and release of arrested abusers now. Granting immediate freedom to an individual who has violently assaulted and hospitalized a defenseless young girl or woman is incomprehensible to me. The strangulation charge needs to be taken more seriously. It's holding someone's life in their hands. Letting them breathe or not breathe. Think about that. This is a high-risk factor that should make someone be considered a violent offender. How is it not? Our system allows offenders to exist, completely unmonitored, as if nothing has happened. Survivors are forced to live in constant fear of being abused again by the same man. This is not right. I know we can do better. Let's work together to be part of the solution that stops this violence. Please take our heads out of the sand and make change now. Thank you for your time.
Thank you, Mr. Broadfoot. We will now turn to Ms. Wambach from the Canadian Crime Victim Foundation, as she's online. I'll just give it a few seconds for Luzanne for you to start speaking, but if we do hear you, then please proceed. You have 5 minutes.
Okay.
You'll need
Thank you for.
You'll need to turn
sorry.
your camera on if possible, Ms. Wambach.
Oh, sorry. I'm new at this, so
So am I.
hopefully, no, for some reason it's. Oh, okay.
Yeah, we
there
see
you
you.
go.
Please go ahead.
Okay. Thank you for inviting me here to speak about this very important issue. The entire court process is huge, causes huge stress and re-victimization for the victims and or the family members who are also very greatly affected and can be considered as victims as well. From lies told by the defense about the defense lawyers in court about the victim with impunity, to the victim service, which a lot of victims tell me make matters worse. And in our case, they didn't even offer to help us. We didn't get any help from them. And finally, and the terrible, terrible legislation around bail, parole, and sentencing. Offenders are let out on bail, receiving life sentences, and then out on parole, often to reoffend. Because after all, there's not enough parole officers to watch them. So what does that say about the value of the lost or compromised life? Well, the victim has no importance, no value, is disregarded, and is lost and alone. In our case, the three offenders were out on bail for 4 years before they were in court. The one who kicked my beautiful blue-eyed boy's head like a football into brain damage was out in the community wandering around free while we were imprisoned in the hospital, reoffending with impunity, as we found out by reliable word of mouth. After the release from the hospital, I was in constant fear that he would find my son at his new school, which wouldn't have been very difficult, and push him down the stairs or hit him in the head again, at which point he would surely die. I fell into desperate depression and panic attacks, feeling I could not keep Jonathan safe. And I couldn't. I had no control. But much, much worse than that, Jonathan was constantly terrified, having nightmares, night terrors, depression, often yelling that he wished he was dead, frequently suffering from brain injury rages, trying to hit his head against the cement floor in our basement, while Joel, my husband, and myself, we tried to restrain him, holding his head. And then afterwards, my husband slumped into the couch, clutching his chest. And soon after, he developed heart disease, which he suffers from terribly even now. After their short sentence was served, this was all repeated again. Jonathan suffered great emotional stress and saw an irresponsible social worker who used inappropriate therapy, contraindicated for any frontal lobe brain damage, resulting in false memory syndrome, concerning his childhood, causing him to become estranged from us for 11 years now. We are in absolute despair, and none of this would have happened if he wasn't kicked into brain damage. It was because of this crime, because of the attack. Olga Baranovsky, the mother of homicide victim Maddie Baranovsky, told me she was dead inside after the murder of her son, and in fact was found dead in her apartment, all alone. Her life was over because of this crime. The victims are the true recipients of the life sentence, not the offenders. They go on with their lives. We don't. We suffer. Insomnia, depression, panic attacks, and other mental health issues, we are lost and alone and in pain. The offenders are let out and continue to receive free psychological support. In fact, the correctional investigator said recently that funding for psychological help for the inmates should be increased. But isn't it funny how there's no mention about the psychological support for victims? By the way, we received no psychological help unless we sought our own, at our own cost, of course. With this legislation, there will be more victims, more families will suffer, and there will be more re-victimization, and it will go on and on and on, affecting more and more people. And in closing, I just want to ask, there's a victims ombudsman in Ottawa. What are they doing? I haven't heard anything. And also another thing I wanted to mention was that it's so easy to find support and funding if you are
Ms.
starting a
Warbeck,
group
your time is complete. Just take a few seconds to conclude if you could, and we'll have plenty of opportunity to ask you more questions.
Okay. So do you want me to just finish what I was saying, or?
Just if you could, in like 15 seconds.
Okay, well, just that the funding for the victim-initiated groups is like very hard to find. And thank you so much again for this opportunity.
Thank you. Colleagues, we'll do our best to get these 2 rounds in, so we'll go with Mr. Brock, Chang, Fortin, 6 minutes each, followed by Lawton, Maloney, Fortin, Baber, and Dillon. Over to you, Mr. Brock.
Thank you, Chair, and thank you to all the witnesses for your attendance, particularly the witnesses who are here advocating on behalf of family members and personal experiences. My heart goes out to each and every one of you. In fact, my entire Conservative team will always stand in solidarity over victims, over accused, always. And one thing I want to highlight, and I feel like a broken record when I say this, the number one responsibility for a federal government is to keep us safe. This federal government, under the so-called leadership of Justin Trudeau and now Mark Carney, to you, Ms. Basil Cobb, has failed your daughter, has failed to implement the necessary changes to keep her safe, has failed to bring in mandatory detention in high-risk IPV cases, has failed you in terms of strict enforcement of no-contact orders, has failed you in terms of increasing sentences for violent repeat offenders. For the last 10 years, all that we have heard is promise after promise after promise and no deliverables. It started with C-75 when they made it easier for repeat violent offenders to be recycled through the justice system, catch and release. They followed up with C-5, eliminated mandatory minimum penalties for serious drug offenses, all drug offenses and serious gun offenses. They made it easier for sick mass murderers like Paul Bernardo to be transferred from maximum security to medium security to enjoy the comforts. Because why not? Liberals have always favored the accused. Yeah. And to you, Ms. Wambach, your considerations and concerns, what about that victim ombudsperson? Yeah. For almost a year and a half, this failure of a Liberal government did not appoint that person. And that person right now does not have the necessary tools to keep victims safe. Yeah. So I apologize to you that your government has failed you so miserably. To you, Ms. Alexander, one thing that struck out to me as very important, your phrase, almost as if the government wants this. Can you elaborate on that?
I think it's pretty obvious that we have a problem here, and having, with a lot of my friends here, the social outreach of millions and millions of people saying, what is this government doing? Why are they favoring the criminals? Why are they not holding obviously dangerous people accountable? And I feel like a broken record. I feel like I'm banging my head against the same walls the way that my ex did to me. This government has been an extension of the abuse that my ex committed against me. And I don't understand what color of red they need the blood to be. How many of us have to die? How many times do we have to say, repeat, suffer before we get both sides of the government? This is a nonpartisan issue on the same team so that we put criminals away and protect the public.
Right. Yeah. And you specifically pointed out Mr. Maloney for making promises to you a couple of years ago. Have other members of the Liberal government made similar promises that were simply not kept?
I tend to use this experience. In April 2024, I sent a letter about my experience in the injustice system to Pierre, to Jagmeet, and to Justin. Pierre responded in 48 hours. Justin responded in 7 months, and Jagmeet never did. And then the committee meeting July 31st, 2024, where the Liberals and the NDP put a motion in about abortion, and I was forced to walk out of a committee meeting just like this, because clearly clearly you have to know at this point that this is wrong and that something needs to be done and that this leniency to criminals is just going to end up killing more people. Clearly you know that now. We are screaming it up the rooftops. It's in every single newspaper, every single headline. The media is frustrated with it. Why aren't you doing something about it? Seriously, something serious about it.
Ms. Alexander, and you're absolutely correct. For years we've heard, you know, it's all in the imagination of the minds of Canadians. It's not our problem, it's the provinces, it's provincial judges, it's lack of space, never accepting responsibility for their own abject failure. Now they brought forth Bill C-14 called the Bail and Sentencing Reform Act. There is one provision that increases sentencing. And you would think, given the myriad of serious violent offenses we have in this country, including IPV, you'd think they would address it? No. Their focus is on contempt of court. People who are subpoenaed to give evidence and choose not to, they want to increase the penalty from 6 months to 2 years less 1 day. It shows a lack of priority on that side of the House when it comes to your rights. That's what we'll fix.
Thank you, Mr. Brock. Mr. Chang for 6 minutes.
First of all, thank you all for being here with us today. Thank you for your courage. Your painful stories and your perspectives are very important to this committee. Protecting every daughter, every child, and every family is exactly why we are strengthening bail, toughening penalties, and investing in prevention, because safety is achieved through action, not slogan. Mr. Bradford, I'm deeply sorry for your loss. What gaps in the current bail process do you believe most directly endanger victims or the general public?
Well, Mr. Chang, I think it's already really been said, but I guess I'll reiterate it. The gaps are widely huge. I mean, for my daughter's offender, who was charged with, as I mentioned in my testimonial, of strangulation. Why is this individual even being released with a piece of paper that says not to communicate, not to do this? It's worth about as much as the paper it's written on. We have no monitoring systems for these individuals once they're out. They go unchallenged every single day and are asked to appear for their charges 3 months later at best. So there's some severe gaps. Imagine yourself, somebody putting their hands around your neck and giving and deciding whether or not they were going to let you breathe. Should that not be a violent act? Should that person be allowed out on the same day they committed that act? So to answer your question, I think it's pretty obvious.
Thank you. And based on your experience, does Bill C-14 actually address the risks posed by violent repeat offenders? And if not, what amendment would you recommend?
Well, no, it doesn't. It was just mentioned by the panel as well. I would recommend that at the very least, if you're going to continue to tell us that these offenders cannot be incarcerated in due time and are just released, that is there not such a thing as house arrest? Is there not such a thing as proper monitoring systems? I mean, I believe we live in the year 2025. We have a lot of technology, a lot. And I think that we have the ability to do a better job monitoring these offenders and abusers than what we're doing now. And the archaic way that we form, allowing them to walk our streets, is literally killing people and leaving these women and girls and these people that are being abused to live in fear and hide. And I just don't buy it. I cannot believe that it is happening in our communities. I don't know if that answered your question exactly.
Yes, thank you, Mr. And my last question to you is, do you urge all parties to support this bail and sentencing reform and pass it without further delay?
I would absolutely ask the parties to, again, this is a nonpartisan issue. You need to come together. You need to understand. And at the very least, think about your own daughter, niece, mother, grandmother, whomever, best friend who may be a female. Think about them. Think how you would feel, how the ripple effect would affect you if they were attacked or taken from you in this manner. Let's come together here, people. Nonpartisan. Let's just do it.
Thank you, Mr. Bradford. And my next question goes to Ms. Cobb. I am very sorry for your loss, and thank you for standing up for your daughter today. Do you believe Bill C-14 goes far enough in addressing repeat violent offenders, or are there any additional measures you feel are missing?
Definitely not. The answer is no. Nothing can change what happened, but you guys can make the change. And having it stronger, making better decisions, you guys have the capability of doing it. All I can say is we talk about those changes for years, and I don't understand why we're so fearful. But I guarantee that if it was your daughter or sister, you wouldn't be as fearful and you'd make that change quicker.
And what messages would you like parliamentarians to hear from victims and families impacted by repeat violent offenders navigating the current justice system?
Actually, I'd say to the victims and their families, the system's busy. Judges are overworked. I'd say to the criminals, you know what, there's a lot of loopholes in our system. There's no consequence. You'll get a slap on your wrist, so have at her, because there's no justice.
Thank you, Mr. Chang.
Thank you.
Monsieur Fortin, à vous pour 6.
Mr. Fortin for 6 minutes. Thank you, Mr. Chairman. Thank you to all of the witnesses who are here with us this afternoon. I can barely imagine the suffering and despair that these losses could cause for you, and the circumstances particularly in which these things have happened. To lose a child, and then to lose them in the circumstances that you're testifying about this afternoon, I just wonder if anything could be worse than that. It's awful. I don't know what to say to you, except that I have tremendous sympathy for you. Ms. Cobb and Ms. Alexander, you were talking about the delay that's necessary to hear back from parliamentarians. I agree with you. People should be answered more quickly, especially under such circumstances. But above all, in cases such as these, I'm not a member of the government. I'm a member of the Bloc Québécois. We're an opposition party. And I daily criticize the actions of the government. I'm not always in disagreement, but I don't agree with them always any more than I agree or disagree with the Conservative Party and what they says or does, rather. And I agree with all of you to say that the issue before us today is one that is nonpartisan. But when we talk about children who are murdered, I don't see how we can use situations like that to make political arguments, and I will not make any. I don't have any difficult questions to ask of you, and I unfortunately have no solutions. I can't say today that I would do something to solve your problems, and I don't think you'd believe me if I said so. But I can tell you that you are being heard and that your testimony will be taken into consideration in our debates. How all of this will end, I don't know. there are several factors to consider. Obviously, protecting victims is our concern. And I should actually say we should avoid that there be any victims. That should be the main concern. But we have to take into account all of the issues. We have to take into account the society in which we live and the rules that we have given ourselves, individual freedoms, the right to freedom, and the right to not be put in prison without significant justifications. So all of those issues must be taken into consideration. And I won't surprise you by saying that we can't put everyone in prison. Just to be sure that there will be no more crimes, we'll be in jail ourselves. But we have to be diligent. And the delays that are currently in place are not always applied as they should be. And it results in more than troubling situations such as yours. I don't have questions for you. I said it at the outset, but I might stop myself here and say that if any one of you wants to take the floor and speak a bit more, I invite you to. So, Ms. Cobb, I'll invite you first if you have anything you'd like to add to your testimony.
Wish that we could have the ankle monitors for anyone that breaches our laws, domestic violence, if you've been charged with a criminal offense, something other than just a piece of paper, a restraining order, it's not doing anything. It's not doing anything. And I would love for them to be monitored. That's all I ask for. Thank you.
Merci, Madame Cobb.
Thank you, Ms. Cobb. Ms. Alexander, you were interrupted earlier. Would you like to add something to your testimony?
In this country is not protecting victims, it's actually producing more victims. And we would really like to see the sex offender list be public. I think that makes a lot of sense. We would really like the government to understand the psychology of abusers. And I think that that's where we need to base laws. These are not normal individuals. These are dark triad, Machiavellian, psychopathic, antisocial, and narcissistic personality disorders, chemical imbalances that produce the recidivism rates of these crimes that we see so often. And it is not a majority of the population, it's a small subset of the population that keeps getting away with it. And so we need to understand that if someone is charged with strangulation, they are going to do it again. That needs to be the assumption. And I know innocent until proven guilty, but right now it's innocent until she's dead. And so we really need to understand that particularly around sexual assault and intimate partner violence, the recidivism rate is so high that one charge should be in bail, that's it. And we need jails to be better. We need people to get better in jail because when they get out, after being in jail, they generally are worse. So we've asked at my organization with the province, and we've been working very closely with the Ford government and have made an ally there about dealing with these issues and how we can train the judges better, how we can train and provide the tools within the jail so that we can rehabilitate some people. But I'll be honest with you, there are some criminals that cannot be rehabilitated, and we just have to deal with that and throw away the key.
Thank you, Ms. Alexander. We're moving to the second round. We'll start off with Mr. Lawton for 5 minutes, Ms. Dillon for 5 minutes, Monsieur Fortin 2 minutes et demie, Mr. Baber 5 minutes, Ms. Lattanzio 5 minutes. Go ahead.
Thank you to all the witnesses, not just for your time here, but for the pieces of your soul you had to put on full display here. I think, certainly I speak for my colleagues, we all felt it. We didn't just hear it, we felt it. And, I'm new to this chamber. I make no comment as to what's happened in previous parliaments, but I certainly came here largely to deal with some of these issues head on. So I thank you very much for helping us do this. Mr. Broadfoot, I met you this summer at one of the vigils for your daughter, and I saw how the community in London had rallied around her and celebrated her life and all that she did in her 17 years. And sadly, we had to acknowledge all that won't be in the decades that should have come of her life. And I know that you never wanted to have to be the advocate you are, but you have, and we are better off for it, and I'm grateful to that. And you made a comment which is so painfully obvious, but I think it bears repeating here, that if your daughter's abuser had been behind bars, your daughter would still be alive. Now, we have heard testimony from some of the academic set, some of the witnesses that our Liberal colleagues have called, who like to put an emphasis on the rights of the accused. But there is only one life. There's only one shot that we have when intimate partner violence is at issue here. So explain your message, if you could, Mr. Broadfoot, to those who believe that this is an abstract discussion about rights and not a life or death issue for women and girls.
Thank you, Mr. Lawton, and again, thank you for being at the vigil this summer. It was greatly appreciated. How do I answer this? I mean, again, it's if you're defenseless, a defenseless woman or girl, and you're being attacked by your male partner, which is, the statistics show that this is it's a high statistical matter when it comes to the males abusing women. How is this individual supposed to try to protect themselves? We look around, even this room, this committee, and we are bigger than the average woman that is here. And how do they do that? How, again, can putting your hands around somebody's neck, I'll repeat it, literally saying, I am going to decide whether I'm going to let you continue to breathe. How is that strangulation in itself, if you are charged with it, as my daughter's abuser was on the first offense? How is that individual allowed to walk out of that police station on that same very day? And as Jacqueline mentioned, I have not met her personally, but we are unfortunately family. How are we not monitoring these people? And I use that word very loosely. I prefer the word monsters.
Yeah, I agree. I thank you for that. I'll ask you, Ms. Alexander, I know you've seen at least some of the testimony we've heard to date on the committee, and when you hear people talk in the abstract about the rights of accusers, what does that mean to you?
I wish you could be inside my head right now and know what it feels like to have a 6'3", 225-pound male beating your skull into the floor. I wish you could see the blood that I tried to wash out of my hair in the shower. I wish you could understand the fear of being confined to a space by someone who is double your size. Why in wrestling do we put people in weight classes? Women can't fight this. I asked my stunt double, I said, you're a black belt in all the millions of things. Would you have been able to take him on? She's like, not a chance, Kate. If he, an abuser in that mindset with the adrenaline and the testosterone running through them, if they want to kill you, they will. And I'm alive for the grace of God, of my friends who got a 2-word WhatsApp message. I'm alive because I let him beat me. I had to just let him, because if I fought him back, it got worse. So I just took it and somehow survived. I wish you could understand that, and I'm not allowed to bring props. I got in trouble for that last year. But I can show you the videos and photos of him doing this and the blood splattering. I can show you my black and blue body. I need you to understand that when you're making policy choices. This is not a joke. It's real, and it affects your system for life. and it rips families apart. And it's actually more expensive to do what we're doing right now from a financial level because there's so many financial consequences for abuse. You can't work, you can't function properly, and it costs billions of dollars to not deal with these individuals properly. Billions of dollars. We need to do better because this is real. And I'm alive by the grace of God. Unfortunately, Brianna, unfortunately, Madison is not. But I know what their daughters went through. I just live to tell the tale. So I want you to understand, everyone in this room to understand that and take that and get over your partisan bullshit. Get over it. Thank you.
Thank you.
Mr. Chair, if I may, can we request that Ms. Alexander provides any visual or written materials that she is comfortable with to the committee?
You want me to show it on my phone right now?
No,
I've got it. We can play it.
it wouldn't be understanding what you're suggesting, Ms. Alexander. I don't think it would be appropriate at this moment, but certainly you could submit it to the chair and to the.
I was screaming
To the
for my
committee.
life for Michael to stop. We can play the video if you want. Put it on the big screen.
Thank you. Ms. Dillon for 6 minutes.
Thank you, Mr. Chair, and I'd like to thank all the witnesses for being here today and sharing the tragedies you've gone through and the loss of your children. It's something that needed to be heard, and thank you for your courage. And it means a lot, I think, to all committee members across all parties. And you are all right that it should not be partisan. None of this should be partisan. And I thank all of the witnesses for repeating this here over and over again. In 2022, I don't know if you know, I presented a bill, C-233, also known as Kira's Law, and it had to do with intimate partner violence. And in 2023, it received royal ascension with unanimous consent from parties across the aisle. Everybody unanimously consented in Parliament. It became a law. And what this law did, it amended the criminal code. And for the first time ever, we even addressed coercive control, which is where a lot of this starts from. And when we look at coercive control, most often it's a stepping stone. And this was never, ever considered as part of the argument. And in Kira's Law, we also saw that judges, and you mentioned Mrs. Basil Cobb, that they need, and Mrs. Alexander, you as well mentioned, judges need better training, judicial education. So this was changed. Electronic monitoring, you mentioned this as well. It requires justices to consider using electronic monitoring as a condition for release orders. And the bill was a result of the advocacy of Kira's mom. This too was very, very painful, the testimony we heard at that time in 2022, 2023. And we saw during COVID everything that was happening, the intimate partner violence, how it shot up. Could you please talk to us a little bit, maybe Mrs. Basil Cobb, we'll start with you, about coercive control, and if we could focus on that and see what better we can do, because these are changes we all did together, we all made together. I presented the bill, but I thank again all parties, and it went to the Senate, and it quickly passed and became part of Section 515, and there are other sections. And then across all provinces as well, we saw that they noticed Kira's Law, and similar laws were enacted. So, Mrs. Basil Cobb, if we could start with you.
If I could just pass it to you first.
Yeah, absolutely. Thank you. There was a bill tabled by Laurel Collin, NDP 332C, which had unanimous House support, ended up in the Senate at second reading. I'd like that bill to be resurrected. It's thorough. We've added as stakeholders to it. I think that everyone in this room would do well to resurrect that bill, because that would make coercive control a crime, and coercive control is always present in abusive situations. And so that would give the police the grounds, because the problem is right now you have to wait until someone's bleeding before you can press any charges. And so that coercive control bill would help save lives before the blood gets drawn. We also need an amendment to Jordan's Rule, because I know it was done in good faith, but the road to hell is paved with good intentions. Jordan's Rule needs a giant asterisk or a notwithstanding clause usage. We should not be timing out cases simply because we don't have the resources or it hasn't been funded properly. We should not be throwing out. I think it's 30% of sexual assault cases get thrown out under Jordan's Rule now. So that's 30% more offenders that are just out on the street simply because we didn't get to go to court. Those are 278 of the criminal code is another one. In the current law, the defense counsel is able to subpoena all of the victims' hospital records, personal journals, anytime they've talked to anybody in law enforcement. They can subpoena the victim's entire life and weaponize it against them in the court. And they do that. So Section 278 is something we need to look at. Bail, Jordan, the 332C, and 278. And I think that would help at least give us a good place to start. But we really ultimately need the court system to be trauma-informed and survivor-centered. Right now, it's the opposite. And it would make my life, I'll never move back to Canada, but it would be the most amazing thing for the country to all come together and say, hey, we're going to do this. We get it. Canada's 20 years behind most developed nations. And so I'd love it if you guys could just do it. Like, really, I think if we could all just get along and get this done and have a justice system that works so that we can have a safe country and have, functioning citizens that contribute to the economy and have good lives.
Thank you so much. And Mrs. Basil Cobb, would you like to add to that?
I was just going to say Bill C-332, or 332, definitely needs to be tabled again, brought back and passed. There's no ifs, ands, or buts about it. It needs to be passed. If I could just ask for anything, especially that bill and all the other ones, Kate, as you've mentioned, but Bill C-332 would allow police officers and everyone to do their jobs easier, more effectively, and keep people safer. Thank you.
Thank you, Ms. Basil Cobb. Monsieur Fortin pour 2 minutes et demie.
Mr. Fortin for 2.5 minutes. After it will be Mr. Gill. 2.5 minutes. Look, I spoke earlier, and I don't intend to add to that, but I thank the four of you for being here with us today. And I reiterate that your testimony will be taken into consideration, and I offer you my most sincere condolences and my sympathies.
For 5 minutes.
Thank you, Chair.
Je pensais que vous étiez.
You're all right?
Thank you, Chair. I would like to thank each and every one of you coming here for witnessing. I know, as Mr. Fortin said, he don't have questions for you, and we are speechless. We are really speechless to hear your story. We heard you loud and clear, and I am sorry that this government has failed you, all of you actually. And please accept my heartfelt condolences on your loss and the struggle you have seen in your life. Mrs. Cobb, I would like to ask you, like, not much, but if you could directly to the lawmakers, what would you like to say them?
I'd like to say we do talk about change. And again, I'm not sure why we're so fearful of making that change, but if it happened to your daughter or sister or niece, you wouldn't be so fearful and you would make that change, and you'd make it now, not later. You do it now. Thank you.
I will tell you that in my capacity, I will leave no stone unturned to make these things. I am, like Andrew Lawton said, I am also a first-timer here, and we will do each and everything in our capacity to bring those reforms that will protect victims, and we have to put victims ahead of criminals. What message would you like to send to Canadians and families about offenders breaching their conditions and being given more chances because of weak liberal laws?
I'm just so upset. I'm angry. It just doesn't make sense to me. I would say to the victims, I'm so sorry. I wish I could help. I know the judges are overworked. I know the system is really, really busy. But again, it's more of a message to the criminals. They can just go ahead with a slap on a wrist and get away with it.
I cede my time to the member from York Centre now.
Thank you. Jacqueline, I read your letter earlier today. I can't imagine. I'm so sorry for your loss. And same for you, Brett. I hate to be the bearer of bad news. I wish I wasn't going to say what I'm about to say to you. It's going to be a bit technical. The police is asking to clarify the burden of proof on these reverse onus offenses. C-14 doesn't do that. We're asking them to codify the removal of the latter principle, which compels judges to release at the earliest opportunity on the least restrictive conditions. I don't have confidence that this bill is going to end the revolving door that our sentencing and bail system has become. The bill doesn't deal with young offenders. The bill doesn't deal with parole. It barely touches on sentencing reform. So imagine right now, Kate, imagine that this passes, that this Bill 14 that they're bringing, that it passes, and nothing changes. And now imagine I invite you here a year from now or 2 years from now. What would you say to my liberal colleagues across the aisle?
Right? This is my third time on committee. It's the same deal. And no, C-14 is not going to work.
Bill C-14 is not going to work. Bill C-14 does not go far enough. I do not understand for the life of me why, listening to the type of testimony that we're listening to today, we're watching some of my liberal colleagues right now not being overly interested in what they're hearing. They have an opportunity. We will get this bill. We can amend it at committee. And I plead with you to please remember today's witnesses. This was the most powerful panel we've had since the beginning of this bail and sentencing study. Let's remember, Jacqueline, let's remember Brett. And by the way, we have offenses against court orders that are now being overlooked, that are subjected to a diversionary framework by virtue of Bill C-75. They're not being prosecuted. This bill does not deal with it. Please ask my colleagues to deal with that. Jacqueline, would you like to do that?
There's unfortunately not time for a response. Mr. Bever.
10-second response.
We've gone way over, Mr. Bever. You went way over time.
Thank you, Mr. Brown.
Ms. Dillon, over to you for 5 minutes.
Thank you so much, Chair. Mr. Broadfoot, I would like to ask you, please, and again, I reiterate on my behalf, and I think everybody on this committee's behalf, our sadness at the tragedy your family has been subjected to. There are no words, and I see you struggling, and I thank you also for coming and speaking about your daughter. can you share with the committee anything you think that is important for us to understand about your family's experience in court throughout this whole process, or just experience in general? If you'd like to add anything, and what more would you like to see us doing?
Well, in order to answer your question, I guess you're going to need a little more knowledge. With respect to, you just asked me about in court. We didn't get that opportunity, right? Her abuser took my daughter's life before his court date, which was scheduled for July 31st of 2024. When the police arrived on scene, he was still in action, and they had to take his life in order to try and save my daughter's. So we didn't get any court in that sense. But my daughter and our family was left from March 15th waiting to see what would happen on July 31st, but unfortunately that didn't happen. So I'm sorry I can't answer your question a little bit better, but I hope you understand.
Thank you. I think you helped everybody to better understand this moment all of you went through, not getting any answers either. And I spoke about Kira's law, and it's something, a private member's bill I had presented, and it swiftly passed through Parliament, through the Senate, to become law, to become part of law. And for the first time ever, we saw coercive control addressed. We saw the Judges Act, where they were to be trained for intimate partner violence, sexual assault, and anything to do with intimate partner violence really became, for the first time ever, I think, really addressed in the criminal code. We spoke about electronic monitoring, Mrs. Basil Cobb, Mrs. Alexander. I think everybody, all witnesses, spoke about the desire for the electronic monitoring, which is available under the criminal code. According to you, do you think, yes?
Sorry, yes.
Yes. So
may
these
I?
are some of the things that we've changed and tried to change. What more would you like to see added?
So, thank you, because you did, when you first spoke earlier, that statement resonated with me, because you used the term the judges have the opportunity to make that decision on ankle monitors and so on. Unfortunately, many of our victims don't make it to that point where these offenders are getting to the judges. I think if it's going to come in, as was just mentioned about making amendments to this bill, that if these violent acts are being charged, that the ankle monitor doesn't have to go to a judge. It can be done at the police station with their lawyers in hand. Let's not let them walk out of these situations or put them and wait until they get on bail. Let's keep them. So we're waiting for a judge to make a decision that is, in, again, my family's situation was scheduled to be over 3 months later. Right? No. Let's bring this back.
Okay.
It should be happening at the very beginning. So yes, when I say ankle monitors and things of that nature, unless you're going to put them in court the next morning, which we know is not going to happen, let's put this into law. You are a violent offender. This is what we do to violent offenders immediately. That's my statement on that. Thank you.
Thank you so much. Thank you.
And thank you, Mr. Broadfoot. We are at time for this panel. I want to take a brief moment to thank all witnesses for their courage and their testimony today. We will suspend very briefly and then resume the debate on the amendment that Mr. Lawton proposed last week. So, brief suspension, everyone. Thank you. ton of time, folks, so as we were debating the sub-amendment, the floor was Ms. Latanzia's. I'll give it back to her.
Oh, yeah, he did the sub-amendment.
Yes,
Okay.
floor was to Mr. Lawton.
So he needs to,
She was already speaking to it. That's what I have from
That was taken out of order, though, because you had recognized me as a speaker, and then she wanted to put an amendment, so you went to her, and I didn't intervene.
Let me just check the notes.
Yeah.
It should be fixed.
But I was on the speaking list, and then because there was a motion from Ms. Latanzio, you chose to recognize that because at the time we thought we had a consensus.
nice to speak, Mr. Chair.
I just have Ms. Latanzio.
Okay.
I'd have to go back and look at the architecture of that, but
If you would find that I would have the floor
yeah,
right
we
now.
just don't have, bring everyone up. As long as you'll have the same information working with.
Yes, thank you. Thank you, Mr. Chair. According to what we recall was that you proposed a sub-amendment, and then there was the end of when you finally proposed a sub-amendment, it was put on the floor of the committee, and then Mr. Brock moved that we suspend the meeting later.
Point of order.
Yep.
If the chair is prepared to recognize Ms. Latanzio, she's prepared to put forth an amendment to a sub-amendment, and that is not allowed procedurally.
What you need to do is get unanimous consent to amend and replace. That's how it would work procedurally, but you're accurate in that. So please proceed, Ms. Latanzio.
Okay. Chair, so I pull back the amendment that was done. I believe it was a session of November 6th, was it not? And so I propose the following amendment to Mr. Brock's motion, and that the meeting at the very end, so Mr. Brock's motion starts with that, given and et cetera, up until the word house, and then we would add the following paragraph, and that the meeting of this Thursday, November 20th, be the final meeting with witnesses on Bill C9. Clause by clause on Bill C9 will commence on Thursday, November 27th, and continue for as many meetings as required without interruption by any other subject. The deadline to submit amendments to Bill C9 will be on Monday, November 24th at 4 p.m. In French to the clerk.
And the clerk has confirmed that you all should have in your inboxes in both official languages the text of the amendment. Procedurally, we need unanimous consent to withdraw her existing amendment. So I'm not hearing that.
Mm-hmm.
So that's just, that kills it for now, Ms. Latanzio. So debate resumes on the sub-amendment. And it's back to Mr. Lawton.
Thank you, Chair. We had, when we first discussed Mr. Brock's motion on the need for a strong condemnation by this committee and by the House on child sexual exploitation and abuse materials, it was stemming from the Supreme Court decision that found mandatory minimums for child sexual abuse and exploitation material were cruel and unusual punishment. Now, since that meeting, I have had an outpouring of messages and emails and phone calls from constituents and people across the country who are very supportive of what we were trying to do with Mr. Brock's motion. And this was then amended, and I proposed a sub-amendment, and central to this is that we believe this is not meant to be a sticky note that can be ignored and disregarded by the government. It is essential that the original intent of our motion, which is now living in my sub-amendment, that this be reported to the House, that remains in place. Now, we had from the Liberal members a proposal that we could achieve this simply by sending a strongly worded letter to the Minister of Justice. I think the Minister of Justice has received many such strongly worded letters from constituents of him and from people across the country. He has chosen to disregard those. So I do not believe that that is adequate. The importance of what we're trying to do is to give the House of Commons, to give all parliamentarians the opportunity to weigh in on this discussion and to do what is the role and the right of all parliamentarians, which is to take the work of this small group that sits on the Justice Committee and, if we need to, have this debate in the House of Commons, especially since the government has not been forthright about what its plan is. Now, I realize that thanks in large part to procedural delays that have led us to only have 10 minutes to consider a sub-amendment, an amendment, and the original motion, we are not going to have time to deal with any of this in the meeting here. And I'm very mindful of the concerns raised earlier in this meeting by my colleague, Monsieur Fortin, about confusion surrounding what happens when a meeting is suspended and all of that. I will be in a moment moving to suspend this meeting and reconvene this discussion on Thursday at the next meeting of this committee, and to do so knowing full well that is what we are going to do. And the request I'll make before I move that motion, Mr. Chair, is that all members are given a proper amended notice in both official languages of what precisely will be happening on Thursday and when. If the goal is to proceed to witness testimony, I expect all members will receive adequate information about that. That is my request, and I think Monsieur Fortin's concerns are entirely well-founded and were preventable. So with that in mind, I do not believe we need to. Well, look, I would love to put this to a vote right now, but I do not believe, from what we've heard from my Liberal colleagues, that we will be able to dispatch with all three motions right now. So I'm, at this point, moving to suspend so that we can reconvene and dispatch with this properly on Thursday.
So this is not a debatable motion. We will vote on it. All in favor, raise your hands. All against? The motion is carried. We are suspended till Thursday.